Isn't it a lot like the
Go ahead.
like the example that's given in Braunston, where you've entered a store 50 times and you say, I entered the store 5 times. And, I mean, that's true. In the course of entering the store 50 times, you entered it 5 times, but it's obviously false if what the purport of this statement is I entered it 5 times rather than 50 times. And the same thing here. You know, I owed $110,000 rather than $260,000.
I don't think so, because the principle set forth in Braunston in that footnote is that understating a number in response to a specific numeric inquiry is a false statement. Mr. Thompson did not understate the number in response to a specific numeric inquiry about how much.
I guess I don't know exactly where this requirement of a specific inquiry comes from. I mean, there can be various contextual things that go to whether a statement is true or false. One of them is, what did they ask you? But there are other ways in which, you know, if I say I made $100,000 and I'm speaking of Canadian dollars, but everybody listening to me is thinking here in the United States, of course they're thinking American dollars. I mean, that's just false if I say I made $100,000 and in fact I made $70,000 or $130,000 or whichever way the exchange rate goes. But, you know, so I guess I don't get this like, oh, it's got to be an inquiry. I mean, there was an implicit inquiry here. The guy was calling to say you got the number wrong. It's just as if somebody had said, did we get the number wrong? And he said, you got the number wrong. It's $110,000 when it was in fact $260,000.
I don't think so, Judge and Your Honor, because the statement he made was tied to the personal note, and that was true also of the call with the FDIC. It's true that a statement that is volunteered can be a false statement. So if Mr. Thompson had walked into the bank and shouted, I only borrowed $110,000 and not a penny more, that would be a false statement. But instead what happened is that there's this invoice about what he owed, and he made a statement about what he borrowed under his personal note. And I think that the clearest evidence that is not a false statement comes from the government's concession on our motion for judgment of acquittal.
I'm totally confused, okay? He took the statement the bank sent to him. I'm quoting him. I have no idea. The numbers you sent me shows that I have a loan for $269,000. I borrowed $100,000, period. So if he borrowed $219, $215, $150, $160, it wasn't the $100,000 he said. I don't see how that's literally true. That's literally false.
Your Honor,
he borrowed more than he said he did.
Justice Sotomayor, I think that by putting the period after the $110,000, we're not getting the full context of the statement. He said a few more words about the circumstances, and then he said, I had a note for $110,000. So that I think that his statement...
So he had a note for $110,000 might be true, but he was asked, what did you borrow? And he said, only $100,000.
With respect, Your Honor,
I don't understand how this is, I think, where Justice Barrett is confused, which is if the question is, did you enter 50 times, and he says, I entered 10 times, it's not literally true. It's literally false that he entered 10 times.
I agree that the hypothetical is a false statement. But Mr. Thompson was not asked how much he borrowed. The implicit question is what the total debt was.
So as I read the jury instruction here, the jury instruction didn't use the word misleading. It said, was his statement false?
Correct.
So the issue here now is, would a rational juror have concluded that this was a false statement? correct?
That's correct, Your Honor.
So I hate the word literally because I don't know what it means. I think that the question is, did he make a false statement? And could a rational jury have understood him to have made a false statement in the way that I read this?
And that goes back to the question presented in the procedural history, Justice Sotomayor.
No, that goes back to, do you get a directed verdict, or is this an issue that we leave for the jury?
It is.
So do we vacate and remand for the court below to decide that?
I think you have to vacate and remand for the court below to decide it, because neither of the courts below reached this issue. Both believed they were bound by a Seventh Circuit precedent called Freed to hold that it didn't matter whether it was false or misleading. The statute captured misleading statements.
Well, however, the
We're
district
talking
court,
about